Let's get started. Firstly, thank you for logging in and taking time out of your schedule to listen to me speak today on the topic of understanding child support. The webinar will run for likely approximately 50 minutes. A little about myself. I've been practicing in the area of family law for 11 years and I'm an associate here at Michael Lynch Family Lawyers. My approach to matters is to have a sound understanding of what the outcome is the client wants. I find that that is invaluable in assisting that person with advice and options. Just to talk very briefly about the firm, we're a boutique law firm specialising in family law. Our firm has existed now for some 20 years and we have 8 solicitors available to advise clients. We offer a fixed fee initial consultation to new clients, which I'll touch on again at the end of this webinar, as well as regularly producing articles and publications for our clients and the public at large on cases, new developments in the area of family law, and what we hope are helpful tips. Today's webinar is about understanding child support. The area of child support is complex. It has been difficult in preparing the webinar today, condensing it into the time period that we have. I will be covering are the basics of the who, what is child support, assessments, adjusted income, reviews, objection, child support agreements, and some case examples if we've got some time. Apologies if I don't touch on a specific area you are hoping I would. I'd be happy to talk with you, take a phone call or an email to answer, and I'll give you my contact details at the end on how you can contact me. The who. The child support scheme is administered under 2 acts of Parliament. The first act is the Child Support Registration and Collection Act 1988. It has 2 functions: establishing the child support scheme, which occurred on the 1st of June 1988, and it provides for the registration, collection and enforcement of child support liabilities, including under court orders, court-registered agreements and administrative assessments. The second act is the Child Support Assessment Act, which took effect on the 1st of October 1989, and it was implemented to provide for administrative assessments. The child support scheme aims to ensure that children receive an appropriate level of financial support from parents who are separated. The parents will be dealing with the Department of Human Services, which is a Commonwealth government department, who delivers the scheme. What is child support? If your client has separated from their spouse or partner and there was a child of the relationship, then it is likely that one party will apply for financial assistance from the other parent in the form of child support. Practically speaking, more often than not, the parent with whom the child or children are living with at the time of separation lodges that application. This comes about either of their own initiative or because they've notified Centrelink of the party's separation. Centrelink will then refer them to the Department of Human Services in order for an administrative assessment to be conducted to deem who should be paying or receiving child support. The assessment isn't automatically made. It does require a party to lodge an application. To be eligible for child support, you must be a parent or a non-parent carer in some circumstances can apply for a child support assessment for a child. It's conditional upon the child being an eligible child, that the child is under 18 years of age, is not a member of a couple, and meets the residence requirements for a child support assessment. To be an eligible child, that child must be born on or after 1 October 1989, have parents who lived together and who were separated on or after 1 October 1989. This is because of when the legislation became enacted. Have a brother or sister who was born to the same parents on or after 1 October 1989 and not be cared for under a child welfare law of Western Australia or South Australia. I appreciate we're not in either of those states, but it is important mentioning as it's not uncommon for there to be children living in a different state with a parent, and you might have a client who's here in Queensland but the child is elsewhere. It's also relevant if a child is with a non-parent carer, that they are eligible or may be eligible to apply for child support in circumstances where the child isn't living with either parent. The big question, how much child support should be paid? Well, to simplify it, and that's very much what I've done, how much child support should be paid depends on the financial circumstances of each party or parent, the age of the child or children, the level of care each parent provides for the child or children, and whether either parent supports another child or children. Depending on if your client is the liable or receiving parent may affect their take on the child support scheme. Each country in the world has their own scheme for child support, and most have issues surrounding that scheme. It's the same in Australia. If you read in newspapers, if you watch current affairs, there are always parents, both receiving and liable, who complain about the formula assessment that's in place in the child support scheme, saying it's not fair or there's not enough paid. Unfortunately, not all will be happy with the scheme, but it is the scheme that has existed since 1989. It's had little change since 1989, and it's unlikely to be substantially changed in the future. So we have to work with what we've got. When does child support end? Child support is usually paid until a child turns 18 years of age. There are some situations where it may be stopped early, and that's if a child becomes self-sufficient, if the child marries or enters into a de facto relationship, if the child is adopted, or if the child dies. We won't discuss today, but there are also circumstances where child support can be paid when a child is over 18 years of age and has finished school. That requires for the child to lodge an application for ongoing financial support from parents. Child support periods. We often get questions about when does a period start and when does a period finish. I've put in there some of the common questions we experience, more so that you can advise your clients if they're asking you of those periods of start and finish. The short answer is you need to have regard to when applications have been lodged, when child support has been paid to, and whether there are any current agreements. Assessment of child support. This is probably the biggest part of child support when people ask questions. So child support payments are calculated according to an administrative formula. As I said earlier, that formula is set by the government and it has now been in place since about 1989. It uses an income shares approach and is based on research into the cost of raising children in Australia. The formula uses the combined income of both parents to calculate child support payments. It excludes the same self-support amount from both parents' income, treating both parents in the same way. It then calculates child support payments based on the cost of raising children according to the incomes of both parents, and then it recognises both parents' contribution to the cost of their children through care. Important to note that parents can always choose to negotiate their own child support arrangements. They don't have to lodge to have an administrative assessment. They can agree on an amount without ever involving the Department of Human Services, and they can then just specify the amount between them and pay that amount. But the department exists as a backup if parents can't agree. So the basic formula involves 8 steps. The first is working out each parent's child support income. So they calculate each parent's child support income based upon the adjusted taxable income minus a self-support amount and any relevant dependent allowance. These are all set out in their Parents' Guide on the Department of Human Services website. They then work out the parents' combined income in a step 2 by adding together both parents' income. They then, on a third step, work out each parent's income percentage by dividing each parent's income by their combined total. Then, as a fourth step, they calculate each parent's percentage of care, and as a fifth step, work out each parent's cost percentage using the care and cost table. I've set out here the levels of care. So as you can see, the levels of care show what the amount of time and the percentage of care calculated in nights. So for child support purposes, it's always calculated in nights throughout a year. So even if a child was spending every day with a parent, if they never spent a night, it won't count for child support purposes. So the percentage of care, 0 to 14% means 0 to 51 nights in a calendar year. Regular care, 14% to less than 35% is 52 to 127 nights. Shared care is 35% to 65%. Primary care, more than 65 to 86, and above primary care, more than 86 to 100%. Important to note that the language that child support uses in terms of percentage of care is very different to the language that the court uses when discussing parenting arrangements. So it's a different dialogue that you have with child support about that percentage of care than you would if you were litigating in parenting matters. Looking at the costs of care, the tables I've put up, which will be on this slide and the next 2 slides, set out the current 2018 tables showing the costs of children. This is calculated from data, and they say this is what it costs for a child to be raised, and this is what the allowance is that's given to each parent. That's relevant for those steps 4 and 5. Step 7 is working. So once we've worked out the percentage and the cost of care, we then work out the child support amount. That takes a lot of time. It is a very complicated formula when you sit down and try and do it, even for accountants, I suspect. So the easier and practical way for your client to have an understanding of what they will be assessed to pay is for them to use the estimator calculator. So I've placed on the slide the link to the estimator calculator. That's on the Department of Human Services website. The estimator takes you through the above points and the steps that I just spoke about and prepares a calculation based on the circumstances inputted. Importantly, the website doesn't record any metadata, so parents can use this estimator calculator over and over, putting in different scenarios and different figures and get different outcomes based on that inputted data, and none of it is returned to the department, so they won't be recording it. If you are particularly concerned, you of course could adjust names and those details, but it is important that you put the right number of nights and the right age for the children, because that of course will affect the assessment. But by far and away, that is the easiest tool and most practical tool that we recommend to our clients, and I'd encourage you to recommend to your clients. It can look at a myriad of different scenarios for them to consider, especially if they were contemplating an employment change or if their income was to increase considerably. Child support can be varied to reflect changes, but for this to happen, the Department of Human Services needs to be informed. So they will not know of any change unless someone tells them. If it's in the positive, it's not likely to be the receiving parent that tells them, so the liable parent needs to inform. Changes that may affect the assessment include your child is turning 18 and is still in continuing education, you and the other parent decide to get back together, the amount of care you provide for your child changes, you have a child with another partner, your child is legally adopted, you and the other parent have another child together, your child marries or starts to live in a de facto relationship, a parent or child included in a child support assessment passes away. So it's important that your clients are updating the department in terms of their circumstances. Non-agency payments. I thought I would touch upon this because we often get asked, but I'm paying for this and I'm paying for that. Legally, the liable parent only has to pay for what they're assessed to pay. They do not have to pay for anything more. However, most parents recognise when we look at the costs of care and what that figure is, that perhaps it is a little light on, and the actual costs of raising a child are quite a bit more than what's allowed in that amount. So non-agency payments, it allows for payments made by a parent to a third party to be in lieu of child support. So one of the following types of payments might be a payment made directly to a payee of an enforceable maintenance liability or to a payee of a carer liability. A payment made to a third party in discharge of a debt, often at separation, that might be a credit card debt or a loan on a vehicle, and of the enforceable maintenance liability. To be able to claim a non-agency payment through the department, you must have at least 14% care, so that's 52 nights a year, and you can only claim up to 30% of the assessment amount. If you were to pay, if your client was to pay a non-agency payment, I'd encourage them before making that payment to contact the department and ensure that it will be deemed a non-agency payment. So as I said, some of the examples of non-agency payments are childcare costs, school fees, private school fees, school expenses, those dental expenses that go with child, essential medical and dental items that are maybe not covered by private health insurance, or your health insurance doesn't cover them at all. These are possible non-agency payments. By way of example, I thought I would show you some examples of where people have been successful and not so successful in having non-agency payments recognised. So example one is Blythe. Blythe is liable to pay child support to the registrar from 1 April 2014, which is the date that Trevor applied for the collection. On the 13th of April 2014, Blythe asked the registrar to credit $200 paid directly by him to Trevor on the 30th of March 2014. Blythe and Trevor intended the payment to be for child support for April. The registrar can't credit the payment under Section 71 of the Child Support Registration and Collection Act. And that's because at the time of their payment, there was no enforceable maintenance liability, and the payment was a private payment to the payee. So because that payment was made on the 30th of March 2014, but yet the period was from the 1st of April 2014, it fell outside the scope. So that's an important, I guess, note to say, make sure you look at when the payments are made and when you will make the payment, because that payment could have been made on the 2nd of April, and then they would have had the non-agency payment recognised. The next example is Morris. Morris was liable to pay child support of $200 per month to the registrar until Petra opted for private collection on the 1st of May 2013. The overdue child support amount of $800 remained enforceable. On the 2nd of June 2013, Morris asked the registrar to credit $600 paid directly to Petra on the 1st of June 2013. Morris and Petra intended the payment to be for child support for the month of May and for overdue child support. The registrar can credit $400 of the payment under Section 71 of the Child Support Registration and Collection Act, as at the time of the payment, Morris had a liability of $200 for May, which was not enforceable, and then the remainder of the payment can be credited towards the overdue amount. So that's how that could be recognised. The registrar can't credit a non-agency payment against a liability that is an agency reimbursement liability, and This includes New Zealand assessments, and New Zealand cannot credit non-agency payments against their liability. So quite often there are people here in Australia who are New Zealand citizens or are paying a New Zealand child support, given that they're our closest neighbours, and it's important to understand that there are intricacies when you're involving New Zealand or indeed another country. Adjusted income for child support. I appreciate that this is probably something that's accountants are asked about all the time. So Section 43 of the Act sets out what is adjusted income for child support. It is the taxable income from the last relevant year of income. It includes reportable fringe benefits. It includes target foreign income, total net investment losses, specified tax-free pensions or benefits, and reportable superannuation contributions. So arguably, it has a wide berth for what's going to be included as income for child support purposes. Making payment. So some statistics that I thought you might be interested in. Most recent figures from the Australian government shows that there's 1.53 billion in outstanding payments owed for child support. 86% of child support recipients, so that's parents receiving, are female. The Department of Human Services has a huge job in trying to manage those arrears payments and trying to manage this scheme. So there are ways that you can advise your client about making payment. So it can be transferred privately between the parents. It can also be made directly to the Department of Human Services. If they had a private collection agreement, which is when they're paying between each other and the paying parent stops, so the liable parent stopped, then the receiving parent can then contact the department and ask that they then collect on their behalf. When the payments aren't made voluntarily, so when the department has to step in, it has a range of powers to enforce the collection of child support, and they include deducting from a wage or a salary and actually going through the employer, intercepting taxation returns, collecting from third parties such as banks, deducting payments from Social Security and other government payments, preventing a person from leaving Australia without paying the debt or making a suitable payment arrangement, and litigation to recover a child support debt in accordance with either the family law proceedings or even civil proceedings. So it is important that your clients are aware that they have different options for making payment. Their only option is not, though, not to pay payment. That gets them into a lot of trouble if they do that. And more recently, the Department of Human Services have been quite active in pursuing a liable parent. So a couple of recent things that they've been doing, you'll recall the government, it was maybe almost 10 years ago possibly, made a bonus payment for people who lodged their taxation returns by a certain period. That caught a lot of liable parents out because they wanted that bonus payment amount, which I think was about $800. And when they lodged their taxation return, the Department of Human Services then garnished that and took it for themselves, and also then had their current income amounts and current address details as well as employment details. More recently, they have been stopping people from travelling. So there's been recent newspaper articles about people being stopped at airports by the federal police and said, well, no, you have an arrears and there is a departure order in place, which means that the Department of Human Services have been given an order to stop that liable parent from travelling. One such case that was reported in the Guardian newspaper spoke about a liable parent who was flying out to Bali, and he was stopped last year at the airport. He owed $350,000, and he obviously had not paid in a significant period of time. For him to be able to travel, he was required to make that entire payment, which he did. So it shows that he had the money, but he was choosing not to pay. So Department of Human Services are becoming more active in that space, and it is certainly something that your client should be aware of. If they do have an arrears, I'd encourage them to get legal advice about that, or be speaking with the department about entering into payment plans, or if they believe that the arrears have been calculated incorrectly, looking at and considering what options they have to object to that amount or what review process might be open to them. We touched on it a little bit earlier about international. So a person may still be entitled to child support if they or the other parent live in another country. Australia operates under a range of international arrangements for child support and has cooperative arrangements with a number of Commonwealth and European jurisdictions known as reciprocating jurisdictions. So no longer can a liable parent avoid paying child support by moving overseas, which used to be something that people did back in the day, but that's no longer really an option for them. Department of Human Services can assist parents with their international child support arrangements, both registering it in an overseas country or having it enforced in an overseas country. Some of the reciprocating jurisdictions I've set out in the on this slide. So you can see there are a number of countries in there. The ones that are excluded are Brunei, Cook Islands, Niue, Papua New Guinea, Samoa, but not American Samoa, and the Yukon in Canada. So if they are excluded, well, unfortunately, that falls outside the net. But out of all the countries, that's a fairly small amount that are excluded. The review and objection process. This is where it becomes quite complicated. So most child support decisions can be reviewed through an objection process. So once there's been an administrative assessment made, any objections can then occur. Most can go through the review process. The ones you can't review, though, are parentage. So if you're saying you're not the parent, you need to get a court order. Or if you're saying someone is the parent and you don't have the evidence to substantiate that. Collection, so that's not a reviewable decision. And departure prohibition orders. So they're those orders that I spoke about, stopping a liable parent from leaving the country. They're not reviewable. If you are going to object to an administrative assessment, it must be submitted in writing to the Child Support Agency within 28 days of receiving the decision letter and 90 days for a parent who resides overseas. Particular emphasis is placed upon the timely manner in which you lodge that objection, so don't be tardy. Make sure you do diarise those dates. They will not look at them if they're filed late, and they don't really accept any excuses. Extensions of time are very limited. So if you make that review decision, what the internal review will then look at is annual wages payable, the cost percentage for a child, the child support income, the child support percentage, and the costs of children. So they'll usually communicate the decision about an objection or an assessment change within 60 days, unless the parent resides overseas, in which they give themselves a 120-day time period. You're informed of the decision, and until that decision comes down, the original decision remains in force. So you have to continue to pay as per an assessed amount until there's been a change in that decision. Alternatively, if you want to further object, you then need to consider bringing a departure application. So once you've gone through the internal process, you need to then think about whether a departure application should be made. Departure applications are to the court. So it's not through the Department of Human Services or the Administrative Appeals Tribunal, but rather through the court. And it's done by Section 117 of the Assessment Act. So the court must be satisfied before making a departure order that they can make a departure order. So you have to make the application to the court for an order in relation to a child in special circumstances of the case. The court must be satisfied that one or more of the grounds for departure mentioned in subsection 2 of section 117 of the Act applies, and further that it would be just and equitable in regards to the child, the carer entitled to child support, and the liable parent, and otherwise proper to make an order under that division. So in determining whether it would be just and equitable, the court has to have regard to the nature of the duty of a parent to maintain a child, the proper needs of the child, the income earning capacity, property and financial resources of the child, the income, property and financial resources of each parent who is a party to the proceeding, the earning capacity of each parent who is a party to the proceeding, the commitments of each party to the proceeding, and the direct and indirect costs incurred by the carer entitled to child support in providing care for the child, and any hardship that would be caused by the making or the refusal to make the order. The other option and alternative for your clients are entering into a child support agreement. So a child support agreement means that the administrative assessment and the involvement of the Department of Human Services is placed to the side, and the parties then enter into these private agreements, which either can be registered with the Child Support Agency or also registered with the court. There's two types of agreements. One is called a binding child support agreement, and the other is a limited child support agreement. I guess my one bugbear when I meet with clients when they say that they've reached a private agreement with parties, they haven't then documented it. So this is the perfect way of documenting an informal collection arrangement, even if it's just through a limited child support agreement. It should always be documented in my view. A binding child support agreement is an agreement in writing which sets out child support arrangements. A binding agreement differs from a limited agreement in circumstances where, before signing the agreement, each party must receive independent legal advice about the effect the agreement has on rights and the advantages and disadvantages of entering into the agreement. The lawyer who provides that advice will then sign a certificate which confirms that you received this advice. The certificate is then attached to the agreement, and that's an important step because that makes it binding. The agreement can be more or less than the amount of the child support assessment, or what would have been assessed, or what would have been required to be paid under the assessment. And it also must contain formal requirements in terms of addressing under the Assessment Act. Importantly, there has been a recent change in legislation concerning binding child support agreements that relate to the termination of binding child support agreements. So typically, child support agreements or binding child support agreements would have termination clauses in there. So it would say upon the child turning 18, or upon the child becoming self-sufficient, or upon the child, if it was anticipated that they were going to marry or enter into a de facto relationship. They were the typical termination clauses, but recent legislation change, which happened on the 1st of July 2018, but is retrospective, so it means it covers all agreements done, now says that if the care arrangements for a child change less than 35% of all overnights, then that will be a triggering termination event. This is quite significant because it is retrospective. So if you have clients out there who have a binding child support agreement and care arrangements for a child have changed, then this may trigger for that agreement to be terminated. It's important that they get advice on that. It's also important that they speak to the Department of Human Services. We've been drafting these child support agreements for a number of years now, and this was not necessarily something that was anticipated. So this only became on the radar as a possible legislative change in the last 18 months. So agreements drafted prior to the last 18 months may not contemplate this, and it may mean that a new agreement needs to be entered into, so terminating that old agreement and incorporating something about that. To leave it as is, you put it back in the hands of the department, which was the whole reason why you entered into the child support agreement in the first place. Limited child support agreements are a little bit easier. So limited child support agreements mean that you don't need to get independent legal advice. The support amount, though, must be for at least the existing administrative assessment, so it can't be less than. If there is an administrative assessment change by more than 15%, so if it goes up or down by 15%, then either parent can terminate that limited child support agreement. Either way, it will be unilaterally terminated if it's more than 3 years of old. So it offers sometimes a stopgap to parents who are contemplating entering into an agreement to trial doing an agreement, and this is a way that is not as expensive as a binding child support agreement, but there are, of course, some disadvantages to it. The reason why, as lawyers, we might encourage someone to do a binding child support agreement as opposed to a limited child support agreement is really to lock in that amount of money, so it's known both for the liable and the receiving parent exactly how much they will either have to pay or they will receive. It also offers, under a binding child support agreement, options in relation to payment. It doesn't have to be paid each week or each fortnight or each month. It could be paid quarterly, annually. It could be paid on the 1st of September each year. It could be paid through a trust structure. It could be paid through dividends. So it does allow that greater flexibility for the liable parent to be able to structure their finances, but it does also give the receiving parent an assurance through an agreement that is binding that they're going to receive that money. It can also contemplate non-periodic expenses for the children that would normally fall outside the formula assessment. So, things like private schooling. If your child is particularly gifted, there might be an allowance that a liable parent pays for further tuition to go down to the Australian Institute of Sport or to attend a music camp or something of that nature. My tips. I thought I'd give you some of my tips for what they're worth. So I always encourage my clients to download from the Australian government website the Parent's Guide to Child Support. It should come in a PDF form. It's about 40 or 50 pages. I think it's an invaluable resource to them. It sets out everything they need to do and how they interact with the Department of Human Services. I encourage everyone to get on and use the estimator calculator because I think it informs you. It informs you of what your assessment or how your assessment might change. If your clients are amicable with the other parent, discuss options about assessment. Don't let them go to that step of applying. Have the discussion. Talk about the amount. Talk about the collection. But please, don't be naive and don't just rely upon a handshake agreement. Make sure it's documented, or at least you get some advice about how you can protect yourself. Should Department of Human Services be involved, and sometimes that's inevitable, try and limit their involvement just to doing an administrative assessment. They don't have to collect. You can still do that private collect agreement. I always encourage my clients to lodge taxation returns on time and to make sure that they have correspondence with the department about updated financial circumstances when they change. I know that there is that trend out there to not lodge taxation returns and then they won't know what I'm earning and it'll be at the lesser rate. Eventually it all catches up and eventually they'll be in arrears and it'll always come at a time when you can't afford it. So I think it is better to be prompt and proactive. If you're giving an estimate of your taxable income amount, some people are asked to do that, make sure it's realistic. If it changes because you've picked up an extra contract, if you're self-employed or you've changed jobs, update the department. That is a good lead into my next step, which is about keep good records. So interacting with the Department of Human Services, they're going to treat everyone as a bad, liable parent. So they treat everyone as if they're going to try and beat the system. So when you speak with them or when you're communicating with them, you need to keep good records. Start a folder. Keep all your assessment notices. Keep all letters you receive. If you call them and speak to them on the phone, make sure you get the name of the person you spoke with and a receipt number. If the amount of time that the child or children are living with your client changes, get that in writing. So whether it's through a text message or through an email or whether they do a new parenting plan, make sure it's recorded, because best evidence about percentage of care is, well, I've got this text message that said that I'm going to have 6 weeks of the school holidays now instead of the 2 weeks I previously had. It makes it more difficult for the other parent to deny it when there's evidence. Any additional costs paid by you, clarify before you pay them if these will be in addition to or in lieu of child support. Now, that may be a discussion that's had with the other parent if you're amicable, or maybe that's a discussion you have with the Department of Human Services, but you need to be clear about what it all means for you. Payments made by you to the other parent, think about whether you set up a regular direct debit. Think about whether you set up a regular emailing of receipts to you so that you're always tracking it. Make sure that you keep your statements. So we can all be a little amiss in keeping financial records. Keep your statements and make sure that you highlight the entries. Avoid arrears accruing. If you can make sure you don't accrue any arrears, you're going to be far better placed. Department of Human Services have wide powers in terms of collecting. I've seen it affect people's employment because Department of Human Services are contacting their employer and garnishing wages, and the employer just doesn't want to have to deal with that. I've seen it affect people's travel plans because they have had a departure prohibition order. I've also seen it affect some people's credit rating because they're showing these large withdrawals coming out, and banks question that, especially when you're self-employed. The last one, and of course I have to say this, is get legal advice and assistance early on if there's any issues arise. And apologies, I have a typo there, but get the legal advice, even if it's just at the start or at different ways through your matter. Some case examples. I thought it might be interesting to touch on some recent cases. So these were through the Administrative Appeals Tribunal, both the appeals section. So they come about when there's been an administrative assessment, the parties have done the internal review, and now they're objecting further. So the first case that I was going to talk about was decided by the Administrative Appeals Tribunal on the 7th of February this year. So it's a fairly recent case. They had to decide whether to vary a decision made by an objections officer of the Department of Human Services and whether to adjust the applicant's adjusted taxable income for the purposes of child support assessment. So some facts to this. The parties' names are Ruta and Hellier. Now, they're names that the Appeals Tribunal selected, so they're not real people. We always use made-up names in this regard. They are the parents of 2 children. The mother applied to the department for a departure from the formula assessment on 2 grounds. The first being that the father's income, financial resources, property and earning capacity were greater than reflected in the provisional income used by him in the assessment. So in this case, he hadn't filed a taxation return. He was asked by the Department of Human Services to give a provisional or estimated income, which he did, and that's how the assessment was calculated. The mother says that the assessment resulted in an unjust amount payable by him to her. The second ground were that the costs of educating the children in the manner that both parents expected were significant. The father lodged a cross application on the grounds that the mother's income, property and financial resources and earning capacity were not properly reflected in her assessment. That's not unusual. When one parent questions another parent's financials, they often do bring those cross applications. When determining whether or not to depart from the administrative assessment, the tribunal had to consider whether a ground for departure had been established. Would it be just and equitable assessment of child support, and whether the proposed assessment would otherwise be proper. In this regard, the father's 2017 adjusted taxable income was $17,475. It consisted of parental pay leave of $10,761 and parenting payment of $6,714. However, his 2015/2016 adjusted taxable income was $83,700. And it consisted of salary payments totaling $83,844. The father said that he stopped working because he was the full-time carer of his son and he was undertaking full-time studies. He claimed he recently separated from his second wife, but she continued to pay his rent of $1,000 per week, which greatly exceeded his income. The tribunal in this case did not find that the father was a credible witness. On the evidence available to them, the tribunal found that he was not separated from his second wife, but that he'd organised his affairs in a way that sought to minimise his child support liability. So in this case, the tribunal found under section 117, subsection 2 of the Act, that the earning capacity of the parent may be a ground for departure. And in this case, the tribunal considered that the father's earning capacity for what he'd previously earned and what he was now claiming he earned needed to be adjusted for it to be just and equitable. They decided, in light of his credibility, that they didn't accept his evidence, and they found that his evidence supported his expected future earnings to be increased. In this regard, the tribunal ordered that the father would be liable to pay far more child support than what he was currently paying, and that they assess his adjusted taxable income for the 2016-2017 financial year to be $150,878, as opposed to what he'd assessed, what he claimed it to be, which was $17,475. So you can see in those circumstances, the minimising of his adjustable taxable income and his credibility as a witness in terms of why he was doing that resulted in it not being accepted. The next case I was going to talk about was decided by the tribunal, and it was about the assessment of percentages of care. So you'll recall I put up a table that spoke about the percentage of care. In this regard, there were two periods of care that the tribunal were asked to consider. The first being an interim period, which was from May 2017 to August 2017, and the second from the 11th of August 2017 to the current date. The application was brought by the father in this situation, who applied for a review, claiming that the child support assessment did not reflect the actual care of the child for the interim period. He says that he had 100% care of that child in that period and not what was provided for in a court order. So in this case, the mother and father had a parenting order that said that the children would only be spending 27% of time in terms of the percentage of care with the father and the remaining time with the mother. But the father says, no, that didn't happen. The child was with me 100% of the time. This was actually acknowledged by the mother, so she didn't dispute that that was the case. The tribunal had to consider and apply whether the percentages of care needed to be changed in this circumstance. And they had to look at both the court order and look at the reasons for the change in care arrangements. The tribunal concluded that notwithstanding that it was agreed that the father had 100% of the care in the interim period, they concluded that the care percentage in the interim period, so that was from the May 2017 to August 2017, would apply as per the court order, satisfied that the change in care arrangements, so the reason why the child was with the father, was not a ground that the tribunal was satisfied to amend the percentage care arrangements. Moving forward, though, so from the August 2017 period to current date, the tribunal did find that the father's percentage care should be 100% and the mother's percentage care be 0%. I might stop with the case examples. Hopefully I haven't put anyone to sleep. They're not the most thrilling, but I thought I'd touch upon how you get in touch with us. So as I mentioned at the very beginning, we offer new clients a fixed fee initial consultation. This consultation is obligation free, and typically we spend an hour to 2 hours with the client going through options, advice, and answering all their questions. The consultation can be face-to-face here at our offices, which we're located in Brisbane City, or can be by phone or Skype. So we really can cater for most clients, and often speak with clients not in Queensland or in remote parts. It's a great opportunity for a person to get legal advice at a known cost to them. So if you're having clients out there with questions and it's a little bit out of your depth, or you think they could benefit, or they're about to separate, it's a way that they can have a fixed cost but also have that time spent on their matter. Now, just to wrap it up, so thank you again for taking the time to listen to me. I hope that I have further informed you on the topic of child support. As I said, it is a big topic. I apologise if I didn't get to what you were hoping I would talk to. I am happy to take emails and phone calls, and you have our contact details on that past slide. So please feel free to contact me. Otherwise, we will be giving you a survey following this. I'd appreciate your feedback. If it's kind, please be kind. And if you've got any future topic suggestions, they are welcomed also. Thank you.